Hi, this is Curt and welcome to another edition of Fire Law Roundup for June 5th of 2023. I wanted to go over a couple of logistical things. I've got something I got to get done over here. And let me just take care of that or else we're going to have feedback. Okay. So, Brad, first of all, I forgot to give you your sign in here.
I'm not going anywhere.
Yeah, I know. So first thing, we had a couple of schedule changes, and I just want to make sure that that the information is out there. We've got Brad's class this week on Thursday. That's the 8th, June 8th, on the FMLA, sick leave abuse, and really managing sick leave. If you don't comply with the FMLA, you're not going to be able to manage sick leave. It's just going to create problems for you. Your employees are going to have a built-in defense when you try to go after them. And from the union side, you need to understand the FMLA is too. So, but that's Thursday. Next week, Bill Macarone's got his class on overtime for officers. Very important. Is one of the hot areas in the FLSA. But our fire officers, white collar exempt employees,
which is one of our cases today.
Yeah. Are they exempt and thus not entitled to overtime when they work over the maximum hours, or are they hourly employees and eligible for overtime? And then, you get into issues of you have a captain that's on an engine, you have a captain that's at the training division. Can they be treated differently under the FLSA? And we even had a case this week on a fire chief seeking overtime. So, and I think we're going to talk about that. But and then the big one that I really want to talk about is we moved the HIPAA class, brand new HIPAA class. Brad's going to be teaching it. We moved it from June 28th, something about an anniversary or something. I don't know, but we had to move it to, and I'm joking there, Brad, but I'm moving, and Nicole, if you're listening, I'm joking, because I was there for that historic event. So, but we moved it to July 6th. Okay, so but that HIPAA class has been moved to July 6th. So, hopefully, we don't lose too many people because of that date, and hopefully maybe we pick up some additional ones, but we're looking forward to that HIPAA class. But be that as it may, Brad, go ahead, get us started on this week's craziness.
It's weird. So today, I like it, this week's craziness with Curt and Brad. So today we have if you look at the blog, some really long, tedious cases, which I have to say are not that interesting or not that universally interesting. And yet the shorter cases we have are extremely interesting and very universal to everybody. So let's talk about one of the longer and, more specific and I love it because our good friend Dennis Rubin gets mentioned yet again. Rube always says he's the most sued fire chief in the history of firefighters, and he can't even escape this one. In any event, we're going to Washington, D.C. For those who do or don't know Dennis Rubin, he's only a line in this, so I'm not really going off on him.
He's not named. He's
a name. Yeah. No. Just a point in history in the case. But in any event, so we're going to Washington, D.C. Very interesting because firefighter/EMTs, and I'm going to give you people a little bit of history that they recite. They have filed a class action saying that they are going to have to work much longer than any other firefighter. And again, I'll explain this to everybody, because they transferred from EMS where they accrued a lot of let's say service years towards their defined, I think that was a defined contribution program. And now they've been moved into the firefighters classification, right? So from EMS to fire, and fire has a defined benefit program. And these are very different programs. Defined contribution universally is not a third as good as a defined benefit program. Just to explain why this is such a big deal, defined contribution basically says, listen, we're going to tell you what we put in, but we're not going to guarantee you anything, what comes out. If the market does badly, oh well. Right. But defined benefit says we're defining the benefit. You will know what you get. Those programs are always better. This is a big deal. So what happened is in the 80s, according to the lawsuit, DC Fire had very few white firefighters on the fire side. And apparently, allegedly, right? We're not, Curt and I are not saying
DC EMS. DC Fire had mostly white males.
Mostly white males.
EMS had mostly minority and some women.
Right, because they claim that people didn't feel comfortable, minorities didn't feel comfortable on the fire side. So they went mostly to the EMS side where they had the defined contribution program. And at some point they said DC Fire needed more firefighters. So they tried to move a lot of EMS personnel to the dual holding of fire/EMS. And there was two big things other than oral promises. There was legislation passed in the city that said, we are going to move you over and you will participate, get all the benefits. What's happened now, 2 years ago, I guess, informally, somebody made a comment high up, and this was in 21, that said, you're not getting the benefits. But now the lawsuit comes 2 years later because there was apparently a formal action taken where they absolutely made clear you're not getting the benefit of moving over. So what happens is the lawsuit says, listen, we've got to work 15 years longer for those who came from EMS to fire than those who are just straight firefighters. And we have to work 15 years longer. So this, again, it's very specific to DC. I can't imagine this ever would happen in any other place again. But that's the suit, and it you know, on its face, it seems pretty legit. Because
I think there's really kind of two arguments that they make in the case, and one is sort of a breach of contract action, that you promised us that if we transition from just single purpose EMS to dual purpose firefighter EMS, that you would treat us as firefighters and you'd give us our seniority. Our seniority would carry over, and our total length of service combined would only have to be 25 years. Apparently now what they've said is they've reneged on that promise, and now they're saying you have to put in 25 years on the fire side. Forget what you put in previously, 25 years on the fire side. So there's alleging a breach of contract, promissory estoppel, all the things that go along with the breach of contract. Here's the other thing. They're alleging race and gender discrimination based on the things that we talked about earlier, that EMS historically in DC had a higher percentage of African Americans and women. For the reasons that they said. And again, I don't know if that's accurate or not, but there was a perception that they weren't as welcome on the fire side, but they were welcome on the EMS side. But they're essentially alleging that there's some race discrimination and gender discrimination in there. And throughout the complaint, if you read the complaint, they make the argument that the firefighters were always treated better than EMS.
The white, predominantly white, institution of the firefighters.
And I think that's really, we hear that. I've heard it in other places, but to me, I'm trying to think of a good metaphor for, EMS. EMS is a tough job. I wouldn't want to do it. Okay. Firefighting is a tough job, and I love doing it. So, there's a difference there, I think, in your approach. Who's entitled to more pay? Personally, I don't care what EMS gets paid. I don't want to do it. That's just my approach. But there are other people who really love it. I know you did it for a number of years.
Decades,
okay?
Yeah.
Boston and
New Orleans,
right? Yeah. So hats off to you. But to allege that it's race discrimination or gender discrimination, it's kind of like comparing two jobs, almost like comparing like a prison guard and a police officer. And the prison guards are saying, well, we should get the same as a police officer. Well, maybe you should, but it's not because of race or gender or whatever that you may be getting less. Right. It's a different job. So I think here's
an unnecessary claim.
They filed the claim in federal court, and breach of contract is not going to keep them in federal court.
Correct. And that is the main thrust of this suit.
Exactly. So I think they threw those in. Whether they're going to win or not, I see the case potentially getting knocked out on that issue. I guess that's my point, because I think it's a tough case to make that it was race and not any other factor
Right.
Or gender, and not any other factor that that led to them being treated the way they are. And if they lose on that, the case gets bounced out of federal court. Now, possibly they can refile in DC has a DC oriented. It still is I guess technically a federal court, but it's considered to be the equivalent of a state court.
Right.
So I really think that's probably where the case should have been brought, but who knows?
Yeah. And look, all they got to do is show, to defeat that, to your point, show there's one white person in that mix, who is treated the same as the African-American. But I wouldn't have done it that way. I don't think it's necessary, because they're putting now the court in the position of having to say DC is racist. And there's no reason to do that. If they breach the contract, they breach the contract. Their motivation for doing so is irrelevant.
And it's a pretty clear-cut breach of contract action. I mean, assuming that the allegations are true, that there was one particular chief, and very well-known, well-respected chief from Seattle that came in, Chief Dean, and he came out with a memo that basically said, if you transfer or if you go through the fire academy, become a firefighter / EMT, you're going to have all the seniority, all the benefits of a firefighter, and everything's going to carry over. So it's pretty clear cut that there's a breach of contract. So why muddy it up with these other allegations?
Agreed. All right, we spent way too much time on that, but it'll be interesting. Now, a shorter case in a sense, but let's go to Houston. This has been all over the news. The interesting part is only the firefighter EMS side of things, but this is the case where a male was tased, allegedly, although I think this is all on camera, right? And he was tased as police kneeled on him, right in the chest with the taser, and they put him in the car. Anyway, so a while after the fire department EMS arrives, and because we're not here talking about police issues, unless they mix with the fire, as you rightfully point out here, the firefighters. Now you're going to have to clarify this. The way I read what happened is they transported him to the hospital, but at a BLS level, not with the paramedic, and he arrests. And they said, well, there should have been a paramedic, and the paramedic even is there saying, I wish I went. So I'm assuming that they didn't delay or not provide care. They just didn't send him ALS. That's probably has a much harder chance of winning on a discrimination claim. But nonetheless, that's the case. I find this case way more interesting for the reason you raised. We are starting to see, and I'll flip this back to you, starting to see, and that's the brilliance of what you do that nobody else does, is you're starting to find patterns, right? And trends, and we're able to jump ahead of them now on the show. The trend we're finding, we see this with ketamine and a bunch of other stuff, where firefighters are put in the position of having to assist the police in their efforts. And unfortunately, if their efforts are untoward in this case, or unconstitutional or illegal, the firefighters are brought into those suits, saying you were part of the institution that was, discriminating or whatever, trying to cause them harm. But talk about, because this is probably the most interesting thing today on the show, is the trend you're seeing. Yeah,
it's very troubling. And I did see it with ketamine. I think that was one of the things that brought it to my attention. But I have a category called assisting police, and it could be assisting police at a vehicle accident, assisting police at a EMS run, or just assisting police. But it's a category that I keep in the database, and I've got cases that go back to the 1800s. From my earliest case in the 1800s,
you don't look that old,
up until 2015, I've got a total of 8 lawsuits that involve us being sued when we're assisting the police. Okay, 8 cases over 150 years. Since 2016, and 2016 is the year that Michael Brown died, in Ferguson. Since that time, there's 73 cases. So again, I'm not a statistician, but it seems to me we weren't having nearly as many prior to that point. And since then, and whether or not the cases are the same cases are happening, but the plaintiff's attorneys are not naming firefighters and fire departments. And I think that's probably what it is. I think that now we're finding ourselves in the gun sights of plaintiffs' attorneys. And when they're going after the police department and the fire department was on scene, they're throwing us in there as well. And why that's important is that I think our people need to understand that when you go to a scene and the police are apprehending someone, that is a high risk incident for purposes of liability. It may be not high risk in other ways, but it's high risk when it comes to you being sued. You need to be making sure that you're doing things right and that you document that you've done things right. This is one of those areas that you have to be on your game. And if you're going to be doing things like sitting in the engine, you're the officer and you're sitting in the engine.
Not getting out.
Okay? Not getting out, and you're not documenting things properly, and you're not doing things by the book, you've got to realize that you may find yourself in federal court having to defend what you did.
Yeah. And I think it's easy for firefighters to get wrapped up in, they arrive on scene always late in the incident. What they're seeing is somebody on the ground or in handcuffs with a bunch of police, very agitated, right? They've arrived and their impression is defend the police, right? Because that's what we do. We're the same. They defend the police. So they buy into whatever the police, this is my theory, buy into whatever the police are saying and doing and directing, and we pick up their attitude. If the police are combative, we become combative. If the police are, dealing with these what's that?
Contemptuous is the word. When the cops are contemptuous toward the suspect,
we become that way.
We become that way. Yeah.
And you can't. You cannot get into it, as you're saying. And I think that people, and we have so many that we've done on the show, right? But you've got to have, I'm going to steal something you said a long time ago. We've got to meet with the police. We've got to have policies. We've got to put down the expectations. We've got to make it clear, while they may direct that we take them or don't, how we take the person, how we treat the person. We're not handcuffing them and putting them on their back with the handcuffs under them. We're not handcuffing them and putting them face down. We're not transporting them handcuffed without the police. These things have to be in policy, so the department's not buying into a widespread practice of this type of abuse. And so we make it clear, at least to the top police level, we're not participating in the arrest. We treat the person, that's it. But we're getting trapped into, and I understand how it happens, right? Based on what we arrive for and what we see.
Right.
But don't do it. Don't do it. And if people think something's wrong, say it, right? No, I'm not going to transport him that way. And yes, this goes back to what you and your brother, right? We talk about police fire wars. I'm not going to transport him that way. You need to re-handcuff him. I'm not going to sedate him for you, right? That type of thing. Or no, we are going to take him ALS, or whatever it is. You've got to stand the ground, which is not easy to do when the police like this could turn around and make you the target. And I'm not characterizing all cops this way. I'm just recognizing the high tension scenes that we sometimes walk into and we become part of it.
Yeah. And sometimes, those high tension scenes, the same officer on a different day might not be as agitated, as angry, and as hostile as he is on the day that you're dealing with them. So you've got to respect that. A lot of police departments during a chase, they don't want the officers that were involved in the actual chase being the ones to handle the suspect, because there's a prey drive that kicks in when you're pursuing someone. So there's a lot of things we need to bring our knowledge level up in this area. It is a major area of liability concern. And I would say if I've got 73 cases, I wouldn't be surprised if there's over 500 cases. I mean, I can't possibly enter every single case that happens. Right. I do as many as I can. But when I see 73 and compare that to 8 prior to 2016, there's probably, I would guess at least 500 cases out there. It's not just 73. It's representative of a trend.
Yeah. And I think it's funny, as some of the viewers know, we hold a conference in Oneida County in New York, central New York, every year. Last year we did police, fire, and EMS, who's in charge. This year, I think we'll do police putting EMS and fire in the line of fire, something like that, with focus on these cases and talk about what you should do.
Yeah, there's no shortage of them.
No. Okay, let's now, as you were talking about before, let's go to Florida, which I'd like to go to Florida. Let's go to Florida, and we're going to talk about a fire chief. Now, a fire chief is making a claim. He resigned, so he's no longer the chief, but and it's normally after people resign or get fired when these claims come up. And that's, I'll just say, if you're going to violate the law, I'm not saying they did or didn't. If you're going to violate the law, think of it like, think of your relationship with your employees as a marriage. Everyone thinks the marriage is going to be great, but 50% of them end up in divorce. And when they do, all your secrets are coming out. So I'm not saying that's what happened here, but the facts are pretty simple. You have a fire chief who claims his primary duty was to respond to calls. And although it's not highlighted, he's now saying, and I wasn't paid overtime because I was in, I presume, the executive exemption to the FLSA. And that executive exception, just to kind of give a little bit to everybody, states that to qualify, your primary duty, right? And that's a big word here. Your primary duty has to be the management of the enterprise in which you're employed or customarily recognized department. Okay, so you have to, your primary duty has to be the management of the enterprise, and you must regularly direct the work of 2 or more other full-time employees. And then there's a whole bunch of other possible things, but the focus is on primarily. He claims, and this is not going to be a tough suit to win or lose. He claims that he was primarily a paramedic. So if he is primarily a paramedic, 50, 60, 70% of his time spent on the ambulance, they're going to be in trouble.
Yeah, I think it's a tough case. And, you know, we in our FLSA classes, we get into this in a little bit more detail than we can get into here. But essentially, think about the executive exemption as something that you qualify for, that you're an exempt executive. The fact that once you become an exempt executive, you don't lose that because you engage in some non-exempt activities. All right. And the metaphor, again, I guess I find more and more I tend to use metaphors to kind of explain this. But I think a really good metaphor is the manager of a restaurant. The manager of a restaurant hires staff, schedules staff, orders supplies, deals with problems, really is responsible for the budget. They really manage the restaurant. Okay. The fact that they bust tables when it gets busy, the fact that maybe they have to bring out an order or do things that hourly employees do, doesn't change their primary duty of managing. And that's important, okay? Because the fact if you are indeed the fire chief and you are indeed managing the department, the fact that you go on medical runs, you go on fire runs, doesn't change the essence of your job. However, and this is, we use another metaphor here of a fast food restaurant. Wouldn't want to say McDonald's or Burger King or whatever, but think that type of thing. You can't take a kid who is 19 years old and call him the French fry manager.
Right.
And in an effort to escape having to pay him overtime when you make them work more than 40 hours in a week. You can't just give somebody a title. So when I see a case like this, the question becomes, is he indeed the fire chief? Does he have the authority to hire and fire people in this department? Or is there a fire commissioner or a board that does that? Does the chief come out with policies? Does the chief manage the budget? Or are there other people who do all that? Is he truly a manager, or is he just is that just a title?
Right. But the question everybody's going to want to know is, look, let's assume we're a small department.
Yeah.
Let's assume we've got 10 career firefighters or so, and we need a chief, but we also need the chief to be boots on the ground, right? Not just going to calls as the chief, doing a regular job as paramedic. That I think is a big difference here. But the question I think everybody would like to know the answer to, if you do, and I'm sure you do, is, look, what happens if I'm still the fire chief? I still do all the management, hiring, firing, enforcing, creating, drafting of policies, all that. But in routine, we're a busy EMS department, and I'm regularly going to, and we could change the facts. Primary EMS calls. No, I'm only the second or third EMS call out, right? But if I'm primary EMS and 70% of my time is spent on boots on the ground, yet I'm still doing the chief's job, what's the answer? What's the primary role of that person?
And that's going to come down to a jury question. You know, the jury's going to have to, you're going to have to look at, you know, the scales of justice, and the plaintiff's attorney is going to put on, you know, one side of the scale, all of the things that he does that makes him look like he's hourly. The city is going to put on the scale, and we'll see what happens. Again, another metaphor, the close play at second base. Okay. Right. And we're going to have an umpire there. They're going to, you know, weigh how much he looks like an hourly employee, how much it looks like he's an exempt executive, and then figure it out. Okay.
And facts matter, you know, change. Like the one fact I intentionally pulled out, which is not in this case, but I've had it in others, is do you go on the first ambulance? Do you go on the third? Right. Because that wouldn't be, it would be unusual, let's say, to always have 2 or 3 ambulances out in your area, right? You're a backup, you're intentionally backup, as opposed to you're hired as the first out on that shift and you're filling a shift there. You know, closer question, but that I think is one of the most interesting things we see today, because I think that's becoming very common. I will tell you that in New York State, and, you know, for my conference, we held this lecture too, is, you know, I have 3 or 4 departments going from all volunteer to all volunteer with a paid chief. And the question, but the paid chief is during the day and is going to have to put on turnout gear, right, to be an interior,
like the manager of the restaurant,
on the front lawn.
But it's like the manager of the restaurant. The fact that you have to bus tables, if you are indeed an exempt executive, the fact that you engage in, you know, but again, if you're really a figurehead, like your title, like you're not really the manager, you're not really the French fry manager. You're like a fake manager. We're giving you that title, but that's not really your primary duty.
Yeah. And this is expensive to lose, right? I mean, triple back 6 years, possibly. Yeah. You don't want to lose these things. So, okay. Any event, now we have the most confusing case ever. I'm going to try to summarize this in like a line. This just gave me a headache reading. I got to tell you, not your fault, obviously, the way they wrote this thing, but we're going to Texas. And we have a firefighter who claims he was retaliated against, because he was not merged into it. The retaliation is he didn't get a promotion and he was fired and he wasn't merged into a merging department. He wasn't brought over. And when he applied, he was like, you're not getting the job. And he didn't. So he's effectively terminated, whereas others weren't. And what happened is he participated as a witness in an investigation. And the investigation was about retaliation against a witness in an investigation who was a witness to sexual harassment. That's why this is so confusing. Suffice it to say, look, he's a witness and alleges that he's retaliated against because he was a witness against the fire chief. Really some interesting things. He said, like, you know, I was told with other people to clean out the back of the chief's car, and I found a bunch of Playboy magazines in the chief's car. And the first thing I read when I thought of this is, there's still Playboy magazines? I didn't know that was still a thing.
That's for people who don't have computers, I guess. I don't know.
Yes, yeah. I mean, but they were apparently in a sealed bag, and so he's like, I was being set up, and you know that stuff's a little more tenuous, but not being hired and such. But you know, some comments that were allegedly made to him. But look, let's be clear: if somebody participates in an investigation, you should be providing a written statement. You will not be retaliated against. You tell the person who's involved in the investigation, you will not retaliate against them there. Frankly, I would be running all decisions that affect that person, unless they're like on the line during a fire or something. I'd be running that through somebody else to kind of whitewash them, make sure there's no issue. Don't retaliate against anybody who participates in investigations. And if you have 6 years to try to figure out this case the way they wrote it, more power to you, because that was confusing. It
is a confusing case for sure.
I got a new one for me. A really new one is the last one. We're going to Pennsylvania. Not a new issue, but a new spin on this. We have a fire chief who is charged criminally with failing to report the sexual abuse, alleged sexual abuse by a deputy chief against I think he's 15 years old. So I think the 28-year-old assistant or deputy chief allegedly sexually assaulted a 15-year-old, I think male, female, I don't know. So really interesting. The fire chief allegedly knew about it and didn't report it. Wow. Right. So one, he's charged with, for those wondering, like, what is he charged with? Obstruction of justice. I wonder, and I don't know, in New York State, EMTs are mandated reporters. Firefighters are not. They tried to be added. They were never added to the list. I don't know. In this state, maybe they aren't, but obstruction of justice. Interesting. If he did learn about it, and I'm going to interpret this in how I understand obstruction in New York, which is probably universal, you have to intentionally interfere with the investigation, prosecution, right, administration of justice with regard to a crime. So if he learned about it and then hid it, that would be obstruction, right? If he didn't report it, it would be obstruction. Now, if he knew it was already reported and then didn't make a second report, probably not obstruction if he knew the criminal process was already in place. But this is a big deal. And I think chiefs, this is like the shot heard around the world as far as I'm concerned. I think the chiefs really should pay attention. If there's something criminal happening in your department and you don't report it, I don't care whether it's theft or sexual assault or whatever it is. If something bad is happening, criminal, and you don't report it, this to me is a new spin. I've not seen this before. I don't know what your database shows.
Yeah, I've got a couple of cats. I was just writing them down so I would be able to talk about them. But it's not uncommon. And here's the challenge. Okay, you're the fire chief, and you have two employees who you value. One making the complaint, and one the perpetrator of whatever it was. Okay, and you're trying to resolve it. And these things come up. It could be, well, he called me a name, or he, did something that I don't like. Okay. Well, we deal with those all the time. There's not a problem. But once the allegations involve something that is criminal, and you try to manage that in the house, in-house, you have that potential for, whether it's witness tampering, however you want to characterize it under state law, but it could be obstruction of justice. Now, we had cases, one of the first ones I'm aware of, where a fire chief, and both of the cases I'm going to talk about involved the chief and the assistant chief. So you have 5 bugle and 4 bugle positions, were charged criminally with covering up a criminal act. And the first one was in Shreveport, Louisiana. The second one was in Ellis County, Texas. And these are both over the last 10 years or so. But they had some inappropriate conduct. And here's the thing, I wouldn't get paranoid about all crime. The ones that seem to get us in trouble the most involve some sort of sexual misconduct.
As they should.
Okay, those are the ones. If you have an allegation that somebody fudged a time report, that could be criminal. Okay, I wouldn't lose my mind over that. You have an allegation that somebody inappropriately touched a junior firefighter in the Shreveport. On duty,
right? This is not off-duty conduct, Garrity, whatever, right? This is on-duty conduct. So
yeah,
and had to be reported.
Right, absolutely. And Shreveport involved some sexual improprieties that involved people with disabilities, mental disabilities. Okay, the case in Ellis County, Texas, involved a Portuguese sausage hazing of a 17-year-old new firefighter, some sort of a hazing where they sodomized them with a Portuguese sausage or something or another. And I can understand why. I can understand the dilemma that the chief is in, because the last thing you want is this getting out. But the second to the last thing you want is this getting out. The most important thing is you don't want to go to jail for it.
Right.
And you have to realize that is one of the consequences that's on the table when these allegations surface.
And let's interject for a second to say, don't investigate allegations of crimes in your own department on your own to see whether you think it rises to that level. Is as soon as you get a hint that this is criminal, it should be reported and turned over to somebody outside the department, because you are in a no-win situation if you investigate and determine, I don't think this is criminal.
Yeah.
I mean, you're going to be hung out to dry.
Case in point. So
Yeah.
we'll see where it goes. I mean, there are allegations right now that, you know, he has been charged, but we'll see if the charges stick. I will tell you, in Shreveport, the charges were dismissed against the chief and the assistant chief. So they were not convicted. They lost their jobs, and there was some civil suits trying to get their jobs back.
That's what's coming.
Okay, but the bottom line is they were not sustained. I'm not really sure what happened in Ellis County, and certainly if anybody is aware, please write in and let me know. But I do know that the charges were filed against the chief and the assistant chief in Ellis County, and I don't know what the outcome was.
And either way, look, as we say, and probably a lot of people say, this story is unimportant. It's the headline, right? And here, this headline is never going away. It's going to, it's going to track him. And he looks, unfortunately here, the fire chief looks like he was covering up a sexual assault. I don't know what happened, but it doesn't matter what happened.
Yeah. And I, in any of the cases, I don't think that was the case. The chief is looking out for the reputation of the department, and, trying to manage the overall problem. And maybe they don't believe the complainant. Maybe that's part of it as well, that they believe that the person didn't do it. Regardless, especially when there's allegations of sexual improprieties, you have to report it. It's
right. Right. Don't. Yeah. Nobody should take that on themselves. Right. Bring in an independent investigator, or if it's a civil type issue like theft, but my God, criminal stuff, reported it, and saying that he's looking out for the department isn't a good statement. Right. Well, why weren't you looking out, they will say, for the 15-year-old who's being sexually assaulted in your department? This is just such a no-win for the chief. But when you watch the video, they show the perpetrator getting carried out in handcuffs. If you don't have context to the name, you don't know who's coming out to handcuffs.
Yeah.
Anyway. All right. Well, that's this week. Some really interesting stuff again, and good lessons to people.
Yeah. Well, thanks, Brad. And, please, if you haven't already, click like and share, please do. And if you haven't subscribed, please do. And if we can encourage you to watch a few of our back issues here, that would help us greatly. We need another 400 hours of viewership in order to hit the next mark here for YouTube. So that'd be a big help for us. All right. And that's going to do it for another edition of Fire Law Roundup. Brad, we'll see you next week. Actually, we'll see you Thursday for our FMLA class.